Hello, my name is Lily and I would like to schedule an appointment with Mr. Muazzam and Miss Alfa to get an advice regarding the accident involving my sister. Could you let me know their availability?
Thank you for calling. Miss Alpha and Mr. Muazzam is available only on 10 December 2024 at 9 a.m. Is that okay with you?
That works perfectly with me and my sister.
May I know under whose name is this appointment?
Oh, Linda Morgan.
Okay. The time has set. I will let you know if there is any changes.
Thank you so much for your help. I'll meet you there.
Welcome.
Yes, may I help you? We have made an appointment with you today. Okay. What is your name again? My name is Linda. Linda Morgan. Yes. Okay. We have an appointment with Miss Alpha and Mr. Muazzam, right? Yes. Okay. Then let me assist you. Okay. To their office.
Okay, you may have a seat now.
Thank you. Good morning, Linda. Thank you for coming in today. First of all, I'm so sorry to hear about what you've been through. Let's work together to ensure you get the justice and compensation you deserve. Tell me everything about the incident.
Good morning. Thank you for having me today. I am Linda and I'm here today with my sister to seek a legal assistance from you about a car accident that occurred on 10 May 2024. So this is the circumstances that I encountered during that day. When I was driving home, there is a delivery truck owned by Speedy Logistics. I ran a red light and crashed my car at the junction. My car is at a total loss and I broke my leg and I have been feeling so anxious ever since.
After this incident, my sister had undergone a surgery and physical therapy, which resulted in medical expenses amounting to 25,000 ringgit. Because of this incident, my sister was unable to work due to the injuries and loss of income for 15,000 ringgit, and which made her life miserable because she doesn't have any work.
What has PD Logistics do regarding this matter? Have they taken any action yet?
At that time, the truck driver had pleaded guilty and Speedy Logistics announced that they were willing to take responsibility for the driver. However, they took no action. Instead of awarding damages based on my claim, they questioned several aspects of it. This has left me frustrated despite the fact that I have presented adequate proof to back up my claim.
I understand your worries. Please let us know how to help you with the case.
So we come here to understand the compensation my sister entitled to for the injuries, financial losses and emotional distress.
I'm going to go through this one by one so you understand better. For injuries, you can claim 25,000 for medical expenses. This includes all costs related to surgery, physical therapy, medication and follow-up care.
Section 11 of the Civil Law Act 1956 states that damages for personal injury should compensate the plaintiff for their actual loss. In the case of Sri Inai Pulau Pinang Sdn Bhd versus Yong Hit Swee, the court emphasized that special damages must be specifically proven with clear documentary evidence.
You should keep all medical bills and records as evidence. As for the pain and suffering that you endure from the incident, courts will typically assess the severity and duration of the injuries to calculate compensation.
Next, in the case of In-law Chetchin versus Rajaswari Vijayan, the court awarded damages for pain and suffering considering the nature and extent of the injuries. So, you can refer to Malayan Law Journal reports or AMR, All Malaysia reports, for similar awards specific to fractures and concussions.
Next, financial losses. Your sister are entitled to 30,000 ringgit worth of property damage. This covers the cost of repairing or replacing her car. She should provide evidence like repairing invoices or a valuation report for her car.
Under thought of negligence, Speedy Logistics, through their driver, breached their duty of care by running a red light, which caused damage to Linda's property and injuries. Under Section 3 of the Civil Law Act 1956, damages for negligence can be claimed to cover financial losses and emotional distress, provided they are proven. So you are entitled to claim 30,000 ringgit under the principle of residual in integro, as established in the case of Leong Kok Hin versus Lee Tet Fon, where the court emphasized that damage must restore the injured party to the position they were in before the accident.
Next, your loss of income, which equals to 15,000 ringgit, as you were unable to work for 2 months. You can actually claim for your lost wages.
Under Section 28A of the Civil Law Act, it was mentioned that loss or damage can be claimed up to the actual amount lost if it can actually be proven. So, for example, in the case of Malaysia International American Bankers Sdn Bhd versus Lim Kian Long, the court allowed loss of earnings based on documentary proof provided by the claimant.
Supporting documents such as pay slips or a letter from your employer confirming the loss of income will strengthen your claim.
We also want to know whether my sister can claim for any damages, specifically for the emotional distress caused by the incident. Since the incident, my sister never drive her car again. I feel sorry for her.
Okay, for your claims for emotional distress, you can seek compensation for psychological trauma. Anxiety and fear of driving are valid emotional damages caused by accidents.
So, for this situation, in the case of Fong Xiang Chi versus Yoon Yu Kim, the court recognized psychological harm as a valid claim, provided it was substantiated with evidence. In the case of Chai Ye Chong versus Lee Wee Kiat, it was also addressed that anxiety and emotional trauma, highlighting the need for expert testimony, like a psychiatrist report.
You should document your emotional state and seek professional help, such as therapy or counseling. A medical report from a psychologist or psychiatrist will be critical to substantiate your claim.
As my partner said, your emotional distress is valid and compensable. However, we will need documentation like therapist records to support that claim.
Can you also tell us the steps that we can take to resolve these disputes between me and Speedy Logistics efficiently?
Well, I will recommend you to gather enough evidence as in your medical report, car repair cost, or anything related to your case to support you later firsthand. Then, consider that Speedy Logistics is a company that want to save their face. I would recommend an out-of-court settlement and do a negotiation with them first. By doing this method, you will save your time and money and more flexibility regarding damages as stated in Order 34 Rule 2 of Rules of Court, emphasize alternative dispute resolution and encourages parties to settle disputes amicably without proceeding to trial. Nevertheless, if negotiation fail, I will send a letter of demand summarizing your losses and give them a deadline to meet. In Malaysia, the principle of without prejudice communication is well established, protecting genuine settlement negotiation from being disclosed in court. This encourages parties to negotiate freely without fear that their statements may later be used against them. In the case of Daya Anika Sdn Bhd versus Kwan Ah Kok that I mentioned just now, the plaintiff Daya Anika Sdn Bhd supplied concrete to the defendant Kwan Ah Kok, who failed to make the necessary payment. In response to the plaintiff's letter of demand, the defendant solicitor issued a letter marked without prejudice admitting the debt and requesting an extension for payment. The court determined that merely marking a letter as without prejudice does not automatically render it privileged. For such privilege to apply, the communication must occur during the genuine settlement negotiation aimed at resolving dispute. In this instance,
The court found that no actual negotiations were underway. The defendant's letter was straightforward admission of debt with a request for more time to pay rather than part of a settlement discussion. Consequently, the court admitted the letter as evidence and granted summary judgment in favor of the plaintiff, Daya Anika Sendirian Berhad. This case underscores that labeling correspondence as without prejudice does not guarantee its exclusion from evidence unless it is part of bona fide settlement negotiation. In Daya Anika cases, the key issue was whether the defendant's admission of liability in without prejudice letter could be used as evidence. Similarly, in Linda's case, Speedy Logistics has admitted fault, but they are disputing the extent of damages claimed by Linda, particularly the claim for emotional distress. The parallels of the issue is whether the certain admissions or communication are admissible and how they influence the court assessment of damages. The same case clarifies that a mere admission of liability, even if marked without prejudice, is not protected unless made in genuine settlement negotiations. If Speedy Logistics made any written or any verbal admission during the negotiations, Linda could argue they are binding and not protected if they do not form part of bona fide settlement discussions. This may strengthen her case for damage. As for assessment of damages, while Daya Anika focused on an unpaid debt, the broader thought principles of quantifying damages can apply to Linda's case. The court in Linda's case would similarly assess on her economic losses, which is damage to Linda's car, medical expense, and her lost income. As for non-academic damages, will be referred to emotional distress, anxiety, and fear of driving. However, in both cases, courts will evaluate the evidence presented and determine the appropriate compensation. The dispute in the Daya Anika case revolved around whether the acknowledgement of debt was enforceable, while in Linda's case, the dispute centers on the scope of damages, particularly the subjective claim of emotional distress. This reflects a common theme of assessing the reasonableness and substantiation of claims in civil disputes. Apply all those previous points in the present cases, Linda can argue that Speedy Logistics admission of fault served as a clear acknowledgement of liability, similar to how the court in Daya Anika Sendirian Berhad case treated the admission of debt. The focus in Linda's case will then shift to proving the extent of damages, for which medical records, therapy bills, loss of income evidence, and psychological assessment will be crucial. By doing this, we are letting them know that we are indeed serious in considering to take a legal action towards them. This letter will be considered as a record that may be used as evidence later in a court. As in the case of PECD Construction Sendirian Berhad versus Freehold Point Sendirian Berhad, letter of demand is an important piece we can use as an evidence to argue for the claim if their side refuse to reply to the letter.
If they're still not complying, we will file a lawsuit to them. Well, that's all I can propose.
Oh, before I forget, we also bring the medical report and the cost for repairing my car. May I show it to you?
Yes, can I see it?
Sure. Wait a second.
Oh, your injury looks very serious. How are you now?
I'm okay, but I'm still in the process of recovering. Thank you for your concern.
You're welcome. Well, I suppose that is all from us. So do you follow what we say?
Yes, I understood.
Is there anything else you need to know?
No, I think that's all we want to know for today.
Thank you again for your help. The entire process was helpful, and I wanted to ensure that I was taking the required steps to protect my rights. I am grateful for your guidance along the way. Now that I have further knowledge, I am more confident in moving further with my plans.
Linda, I know the process can be daunting, but you're not alone. We'll handle the legal aspect while you focus on the healing. We will keep you informed at every step.
Thank you. I feel a bit more helpful now.
Thank you.